The court calls the matter of Kooy versus Kooy, case number 2021-5880 DM. All parties and attorneys could please state their name and appearance for the record.
Good afternoon, Sarah Boland on behalf of Party A, Sabrina Kooy, substituting today for Attorney Chris Padal.
Good afternoon, everyone. Today's date and time set for a hearing on a pro-con. There was a stipulation to take proofs. We're doing this by remote technology. The contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, or alteration of content is strictly prohibited. Today's date and time set for a pro-con. And Ms. Boland, in the filing, there's a request to waive the 183-day requirement as set out by legislation. I rarely do that. What is the reason behind the request?
Yes, Your Honor, just simply, easing the parties' transition through the divorce process. And the parties are already following the parenting time and custody agreement. This would just serve to make it finalized, but we understand and if it makes any difference in your decision in waiving it, the parties did sign the consent. The last party signed May 29th, if that makes any difference.
No, I'll preserve testimony so your client doesn't have to come back. And then after the 180 days has passed, I will sign the judgment of divorce. So folks will still be married after today, but they don't have to come back. And after 180 days, I'll sign it because I think the case is only about 63 days old right now.
Understood.
Okay, so with the stipulation to take proofs, ma'am, if you'll raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name, spelling your first and last name for the record.
Sabrina Marie Kooy, SabrinaMarieKooy.
Ms. Boland, with the consent stipulation, you may take proofs.
Thank you. Ms. Kooy, at the time the petition for divorce was filed, had you been a resident of Michigan for at least 180 days and of Kalamazoo County for at least 10 days?
Yes.
Were the allegations in this petition true at the time it was filed, and are they still true today?
Yes.
In the petition for divorce, you alleged there has been a breakdown of the marriage relationship to the extent the objects of matrimony have been destroyed, and there remains no reasonable likelihood of its recovery. Could you please tell the court briefly why the marriage broke down?
Yes, thank you. Our beliefs were incompatible and the disagreements between us became severe.
Thank you. If the court were not to grant the judgment of divorce, would you go back to living as husband and wife?
No.
Are you currently pregnant?
No.
Do you have any minor children of this marriage?
Yes.
What is his name and date of birth?
Cameron John Kooy, November 10th, 2008.
You have agreed upon joint legal and joint physical custody. Do you believe this is in Cameron's best interest?
I do.
Have you had an opportunity to review the judgment of divorce, all of its support provisions, including the property distribution and waiver of spousal support?
Yes, I have.
Do you feel this agreement is fair and equitable?
I do.
Do you have any other questions for me or for the court?
Not at this time. So we will still be waiting for 6 months. That's what you guys were discussing in the beginning. Okay.
Yeah, that is correct. I have no further questions, Your Honor. The judgment and UCSO have been approved and signed by all parties.
Well, what I will do is I'll preserve the testimony. Testimony shows me that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood the marriage to be preserved. I'll preserve the proofs at the 180-day mark. We will sign this, or as soon as we can afterwards, we will sign this, making it official. Any questions, Ms. Kooy?
No, sir. Thank you.
Any questions, Ms. Boland?
No, thank you, Your Honor.
Okay, best of luck to you and Cameron.